Section B, the sources of law.
There are three main sources of law in America. These sources are, number 1, constitutions, number 2, statutes and regulations, and number 3, the common law.
Source 1, constitutions. Okay, constitutions. You do carry your constitution, don't you?
Sure thing.
A while back, this nice bunch of gentlemen wrote this nice document called the United States Constitution. It was just a really nice thing for them to do because this piece of work is a cool thing to have around. You know, borderline Fonzie cool. But I bet all those really nice, really smart dead guys never imagined this country would be ordering pizza over the internet.
Pepperoni, anchovies, sausage, pineapple, bacon, and extra cheese. Word up, Hamilton! This internet action is whack!
But they did foresee that things would change over the years, so they created a legal masterpiece called the U.S. Constitution, which gives lawmakers a framework on which to build the laws that we need to meet our country's changing needs.
See, now that's just what I'm talking about. The Constitution describes how America's government should be, and still is, structured. This document came from years of political battles between colonies and England.
Let's part these constitutional waters and figure out what's hiding in this deep blue legal sea. The United States Constitution is not alone in the world of constitutions. There are also state constitutions. And all of these constitutions have three main functions: separation of powers, checks and balances, and the protection of individual rights.
You may have run into these terms in high school American history class, or more recently, in a college course like constitutional law. For the purposes of this video, and most likely your business law course, it's not important if you know the details behind them. But if you're curious, pick up your Constitution and dive right in.
Other than separation of powers, checks and balances, and protection of individual rights, the U.S. Constitution has one more function that state constitutions do not. It's called the principle of federalism.
Federalism is this thing which refers to a government system in which power is divided between national government and other governments, such as state or local governments.
In short, federalism refers to the planned cooperation between the national government and smaller governing bodies.
Now, the Constitution is the mother of all sources of law. But, as we mentioned earlier, it's not the only source of law. Let's look at the next source of law: statutes and regulations.
Source 2, statutes and regulations.
You are carrying your statutes and regulations, aren't you?
This better be worth it.
Statutes are laws. They can be created by Congress as well as by state and local legislatures. Laws which are created by Congress apply to everyone in the U.S. These laws are called federal laws because they're created by the federal government. And laws which are created by state legislatures are called, now this is a hard one, state laws. And these laws apply only to, now this is another hard one, in that state. There are thousands of statutes which shape our society. They can be basically thought of as rules, and they are sometimes called codes.
And statutes are a bit like the rules your parents placed on you. You break them, and you're going to pay for your mistakes. Like if you superglue your grandparents' teeth to the bathroom counter, or hijack the family minivan and drive it through your neighbor's yard. You're probably going to be in some hot water.
Hey, here's a neato point we can make. Sometimes statutes are not written by legislatures, but by other folks who wish to propose laws to legislatures. These proposed laws that sometimes become statutes are called uniform acts.
More precisely, uniform acts are written by experts and lawyers and then proposed to the state legislatures. But not all uniform acts become laws. Why not? If the state legislature thinks the Uniform Act is important enough to turn into a statute, then the Uniform Act will become a law. Otherwise, the act becomes excellent birdcage liner.
And so the story goes. Each author of the Uniform Acts really hopes that all of the state legislatures across the country will adopt their Uniform Act as law. But that doesn't always happen. Because of this, the laws across the country are not uniform. So not all laws are identical in every state.
This whole Uniform Act deal relates to the concept of federalism. See, the federal government cooperates with the state and local governments, but in the end, they are separate functioning units. Each government makes a lot of its own decisions, including what laws it does and doesn't want.
Like in Nevada, you can gamble, but in Pennsylvania, when you're caught dealing cards and spinning the roulette wheel for money, you get thrown in the slammer. Now, when you want... Hey, what are you doing? I'm an important person, you know.
The important thing to remember is that if one uniform act becomes a law in Montana, it may not become a law in Mississippi. Like we said, don't let the term uniform throw you. The Montana legislature may vote to make an act become a law while the Mississippi legislature kills it. Or Mississippi might adopt only parts of the Uniform Act or make changes to it.
So how about switching gears and catching up with regulations?
Regulations are rules made by federal government agencies such as the Environmental Protection Agency, the Securities and Exchange Commission, and the Federal Communications Commission, along with similar state agencies. We have to follow these regulations when engaged in practically any type of business. Such examples are environmental safety regulations, food safety regulations, trade regulations, and radio and television broadcasting regulations.
These administrative agencies are created by the federal or state legislatures. The legislature writes statutes which state the purpose and necessity of these agencies and outlines the power these agencies have to make their own rules. So, basically, here's how it works. Congress decides whether the country needs a way of regulating, say, trade within and across our U.S. borders. So they say, hey, let's put together an agency that can do that. Congress writes a statute with a description of the agency to be created and a description of the powers that the agency will have to enforce particular rules. A lot of the agencies that Congress creates have a big effect upon business law.
For example, the Food and Drug Administration is an agency which is responsible for enforcing the quality of the food and drugs that are put on the American market. See, a business can't put a new pharmaceutical product out with the approval of the FDA unless it first passes a bunch of scientific tests. So the FDA and other government agencies are given particular powers by Congress. With the allocated powers, the agencies make and enforce rules that apply to their specific areas of jurisdiction. So that's how statutes and regulations are sources of law. Excellent. So what's next?
Source 3, Common Law.
Finally, after constitutions and statutes and regulations, our last source of law is, drum roll please, common law. You are carrying your common law, aren't you?
Yes!
The common law is made up of judge-made law or case law. These laws are different from the Constitution and statutes and regulations. The common law is determined by courts and not by legislatures or governmental agencies. When an issue comes up within the court system that cannot be answered by the Constitution, statutes, or regulations, the courts must rely on the common law.
How about we take a stab at the history of common law? This common law stuff originated in medieval England. Judges began to follow the decisions of other judges when facing similar disputes. Not because they were lazy, of course, but to have consistent, predictable outcomes. Now in the United States, we have our own body of common law, which is made up of the past decisions of judges.
There are two terms commonly associated with common law, stare decisis and precedent. These terms are closely related. In Latin, stare decisis means, let the decision stand. This phrase refers to the judicial philosophy of using previously decided cases to determine what the law is. And similarly, a precedent is a decision which judges have made in a similar case and that will likely control future cases.